We're going to get started with our very last panel. And for all of you on this very last panel, thank you so much for hanging in here with us. This is panel 7, and I'm going to go through the panel participants. We have, you're never in the order that I call you out. We have Mr. Gordon Armstrong, the CJA District Rep from the Southern District of Alabama. Ms. Lisa Cosner, CJA District Rep from the Middle District of North Carolina. We have Mike Mazzoli, CJA District Rep from the Western District of Kentucky. We have Leroy Percy, CJA District Rep from the Northern District of Mississippi. Oh, there you are, okay. And Andrew Skier, CJA District Rep from the Middle District of Alabama. And finally, Tom Stingley, CJA District Rep from the Southern District of Mississippi. Again, we're going to start with a brief opening statement. Don't need to read your submissions because they've been, the committee has had them and had the chance to review them. But if you would make just a brief opening statement, and then the committee will begin questioning. The committee for today will include Judge Dale Fisher. Chip Frensley was on the committee, but he had an unexpected situation, and so Ms. Catherine Rowe will be taking his position. Professor Orrin Carr, Neil McBride is not here, but the rest of the committee will ask questions. So whenever you're ready, we'll start with you, Mr. Stingley.
Thank you, Judge. I want to thank the committee for inviting me to participate in the hearing. I think the work that you're doing is very much needed and very important. So it's an honor for me to be here, even though I've only been the CJA rep since December, this past December. I don't have a specific opening statement. However, I've listened to testimony from yesterday afternoon, one panel, and I've listened this morning. And some of the concerns I've brought with me, I guess, from Mississippi is a lot of the concerns you've heard already about hourly fees and maximum pay and that sort of thing. I put in my comments, which I found is a lot higher than what I've heard the last couple of days, is that I felt like a reasonable hourly fee for a panel attorney would be $175 an hour, which is substantially higher than what I've heard. And the reason I said that is I'm reminded of what a retired state Supreme Court justice in Mississippi told me once, and I won't call his name, but when I started to practice law, he said, you understand that you're not practicing law for your health. And so I look at it as a business. I love what I do. I've spent a lot of times with my clients because I find out it's going to take several interviews before I get the whole story. And if a client pleads and we appear before the judge for a plea hearing, the judge can tell if there's a connection between you and that client. The jury can tell at trial if there's a connection between you and that client. So I try to establish a strong connection with my clients. I spend a lot of time with them. So it costs time to do it, and I expect to be paid. And I expect to be paid a reasonable amount because I'm going to do the best that I can to represent that client. So that was my basis for recommending $175 an hour. I also heard testimony about experts and the underutilization of experts, and I would suggest, drawing upon my 20-some years of private practice, particularly, I used to do a lot of tort litigation, and I've also defended church cases as it relates to sexual harassment and I guess misconduct by clergy. I would suggest that, I don't know if the panel attorney organization should do it or if it should come out of the public defender's office. But one thing that could be done is, just like you have a panel of attorneys, you could have a panel of experts. You could have a panel of investigators who have a proven record or doing a good job in your district. And I think that sort of information should be compiled and made available to lawyers, and it would encourage lawyers to use them because they know they're there. Because I know the other side of the coin is that you're going to need to be able to pay for them. And like an average cost for an investigator in Mississippi is going to run about $70 an hour plus expenses. And the expenses, depending on where they have to travel to, could get kind of high. So that's an issue that would have to be addressed. I've had one lawyer to tell me in Mississippi that we have 54 members of the panel, and he feels that that's a little high. And I mentioned this in my public comments. His argument is if you had a smaller panel of attorneys, they would spend more time with a lot more cases, and they would be better trained. There's two ways to look at that argument. You know, as an entrepreneur, I'm going to be against anything that's going to foreclose an opportunity for someone to make money. So I look at that kind of differently, but I understand the rationale. You need to do more cases to get good at it. I did it in private practice when I handled tort cases, and I don't do as many tort reform kind of shorten that up a little bit, that business. But I used to sue, when I did medical malpractice, I used to sue podiatrists. But tort reform even affected that. But I always needed experts. There was always a disagreement between the experts, but most of the time, if you got a good expert on the front end, you could settle the case before you went to trial. So the use of experts is very important. I know how to use them, but I don't like having to jump through the hoops to get one. I'd rather be able to reach out and get an expert at a reasonable fee and be able to pay that expert when it's time to pay them. Why don't I stop there? I'll stop there.
Right.
Thank you, Judge.
Thank you. Mr. Skier.
Thank you, Your Honor. Good morning, everyone. I'm sorry, good afternoon now. I'm coming to you from a district that is about 90 miles south of here, and I'm happy to report that I think that the consensus in our district is that everything is kind of running pretty smoothly for a district our size, and I want to share with you some reasons that I think that's the case. The first reason, and I think probably the most important reason, is because we have a judiciary that takes criminal defense very seriously, particularly the CJA panel and the Federal Defender's Office. Our judges encourage us to do our best. I've never had a judge in our district turned down. I'm not aware of anyone ever being turned down for extraordinary expenses for experts or for other things like that. Our judges are very active in letting us know as panel members and as the leadership of the panel when and if a problem occurs with a panel member. It's important to them that everyone in the court gets proper representation, and I think that trickles down throughout the community of lawyers. The second reason that I think that we have a very effective panel in our community is because we have a federal defender that sets a very high standard for the level of representation that they provide, and they make themselves available at all times for help with things that panel attorneys need as they go through and learn and figure out these cases that sometimes get quite complex. And the third thing I think is something that is really sort of more nebulous. It's the culture in our community. The lawyers that are members of the panel are widely seen in our community to be the top, we'll just say top 25% of the criminal defense community in our small area, and I think that's important. I put in my written comments. We have recently instituted term limits and come up with a a CJA plan, which didn't exist before. We're feeling our way through it. We had our first round of reapplications this past month, and we did remove 8 members. We had a 38-member panel. We decided that each panel attorney should be getting between 3 and 5 appointments per year in order to maintain proficiency in that area. So we wanted to get the panel down between 25 and 30 members, and we did reduce it to 30 members, 2 of which were removed for insufficient performance, the rest of which were removed for other reasons like moving out of the district or becoming emeritus members of the panel. But the culture in our community, I think, is important, and I'm not sure as a committee how you should go about litigating that or making requirements of that. But I think it's something that will grow as it has in our community throughout the legal community at large. I know that your focus here today, one of your focuses is on habeas representation and capital representation. And I'll just say very quickly, Christine, our federal defender, testified at the last session about the challenges that her habeas unit faces. And I'll just say, basically, it's to use a term from literature, they're depending on the kindness of strangers, basically. Because their obligation is they have to exhaust these state remedies before they can go into federal litigation, and they are depending on volunteer lawyers like myself. I'm currently I've taken on a death penalty case pro bono. The courthouse that case is being heard at is 100 miles from my office. So every time we have a hearing, I drive 100 miles there and 100 miles back to get there, and I'm doing that pro bono because I think it's important. But that's not a way to run a habeas unit, and that's not a way that we in our society should be satisfied with. I think that's improper. And one final comment before I turn it over to my colleagues and await your questions. When we talk about the size of the panel, I just said we reduced our panel from 38 to 30 members. I think there's a balancing test that you have to do, and you have to consider what is the purpose of the panel. Is the purpose of the panel to be a jobs program for lawyers that want the billable hours, or is the purpose of the panel to provide the most effective representation for our clients and those that depend on us? And I think that squarely I come down in the second camp. I think it's much more important that we provide good representation for the people that we represent. I think that's much more important than serving the lawyers on the panel themselves. But I think by serving the lawyers, I think that we do provide and eventually get to the point where we provide the best possible representation for our clients. Thank you for this opportunity, and I'll await your questions.
Mr. Percy.
Roy Percy, Northern District of Mississippi panel representative. I live in Oxford. As I said in my written comment, we have a very small panel. Just based on my experience meeting other panel representatives, I suspect ours is one of the smallest panels in the country, 14 lawyers. And I think it serves our district well, it serves our indigent defendants well. The lawyers have a steady flow of cases. They're in the courtroom a lot. They don't have to reinvent the wheel every time they get a new case. The judges know the lawyers well. The lawyers know the judges well. The judges, we don't have many voucher cuts and other requests for, I suspect we're probably on the low end as far as requesting experts, but I don't know of any expert funds requests that have been denied. I think our judges know the lawyers well enough that if we request something, they take those requests seriously. So I think that's definitely a benefit to our panel. We did have, I discussed in my comment, a $3,500 case maximum in felony guilty plea cases up until less than 2 years ago. I'm sure, I have no doubt this committee has heard over the course of these hearings a lot of tales of trying conditions under which panel attorneys have been asked to represent indigent defendants, but I would put that condition up against any of them. But we don't have that anymore, and it wasn't anything that our district did purposefully. Nobody in our district knew that maximum was unique to our district. And they quickly did away with that, and that has made a huge impact. Prior to that, our panel attorneys didn't really care what the hourly rate was. Every time it would go up, all that meant was that it was just that much quicker that we would get to that $3,500 maximum, and that much more that we would just have to eat ourselves. And so now we can worry about the hourly rate now a little more. Another improvement in our district that is the court has implemented a secure jail video teleconferencing system that is available only to federal defender staff and panel attorneys, and it helps. Of course, no one wants to substitute a video link conference with a face-to-face conversation with a client, but it does help when you've got when time is of the essence and you've got a client in a detention facility 2 hours away, or you just need to present a waiver or something like that to a client that will take 10 minutes and he's in a detention facility 2 hours away. So it's a convenience, and I'm sure it's a cost savings. We've just begun using it. Probably most of our detainees are kept at the detention facility in Oxford, where I live, and so I have only used it a couple of times because usually being in Oxford, I can just go to the detention center and meet with my clients. But it will definitely be a big help to some of our representatives that live in other parts of the district. One other improvement that I neglected to mention in my comment, and it doesn't really apply strictly to indigent criminal defense as it does to just criminal defense in our district in general. We have just, within the last month, our court has adopted a new standard scheduling order in criminal cases. The previous order just had a discovery deadline, a motions deadline, plea agreement deadline. Our new order, previously we had no, defense attorneys had no way to get Jenks material, witness statements, until after a witness had testified. And despite whatever encouragement the court could do to encourage prosecutors to provide that information, because it makes everybody's job a lot easier, it wasn't necessarily happening. Now we have a scheduling order that requires witness statements to be provided at least 7 days prior to trial, impeachment materials to be provided at least 7 days prior to trial, and we didn't have that before, and that's just occurred in the last month. And so just in the last couple of years, we've had some vast improvement in our CJ and indigent criminal defense in Northern District.
Mr. Mazzoli.
Thank you, Your Honor. Let me thank you all, not just for the pleasure of being able to come and address you, but for the immense hard work that you all are putting into this. I was here yesterday, and it was just very evident that you all have made an immense commitment of your time, your effort, your talents, and it is, I think I'm echoing something that was said yesterday, it's a thrill to be able to be here and talk to a group of people who are really passionately interested in the CJA panel and the CJA program, who are really dedicated and putting their shoulders to the wheel, really, and who ultimately will have some influence and has the kind of the weight and the potential influence to make things better. And so I just want to thank you all. I figure that something good is bound to come of all this work, and I want to let me thank you in advance for the improvements. Just by way of very quick introduction, I have been in private criminal defense practice for about 15 years. I have been the CJA rep in the Western District of Kentucky, Louisville, for about the last 10 years. prior to becoming a private lawyer, I was a federal prosecutor for 5 years. And then before that, I was the law clerk for Judge John Hayburn, or unfortunately, the late Judge John Hayburn. And so I saw, both as a law clerk and a prosecutor, how very important the appointed attorneys were to the functioning of the entire system. And I saw that the appointed attorneys in the cases that I was involved in were just of uniformly high quality. And so it was something that I aspired to do as soon as I got into private practice. And so I got an appointment to the panel very soon after I entered private practice. And then Judge Hayburn, who was the chief judge at the time, asked me to be the panel rep. I would say that the arrangement of our CJA panel and the management of it is very similar to what you've heard from the Northern District of Alabama. In Louisville, for the Western District of Kentucky, the court is of central importance and essentially makes every important decision. The court or the clerk's office makes every appointment to cases and handles all the vouchers. That has had, I think, for the most part, it has been to the very great benefit of the CJA program, because our judges, as I sensed from the judges from Alabama yesterday, are committed to fairness and transparency in the way they go about doing their work, and not just lip service, but really and truly live up to that aspiration that they have. Our legal culture is similar to that of the Northern District of Alabama, too. Probably we are about the same in terms of experts usage by CJA lawyers, and probably in terms of fee structure and things like that. We're similar to what you've heard from them. As far as I know, our court has never made it difficult to get experts, get authority to have an expert, and has not made it difficult to get the payments for the experts. The vouchers for district court work are turned around very quickly. If you are under the ceiling, you can expect to get your pay in 4 weeks or less, which I think is a very good turnaround time. For the Sixth Circuit, when you have an excess voucher, it has improved greatly. The speed used to be a real problem, but in the last 4 or 5 years, it has gotten very good. That it still takes about 3 or 4 months. It's what you would kind of expect if you're submitting an excess voucher. Of all the things that I've heard over the last day and a half, the thing that I would encourage the most is increasing the ceilings, so that excess vouchers don't become excess vouchers until you reach a higher threshold. I think the thresholds are too low. Every time you go over that threshold, you're adding several months to the processing. And so you have a private lawyer sometimes asking, do I really want to wait an extra 4 months for this maybe couple $100 that I'm over the voucher? You have a lot of self-cutting. And I just think that the whole process could move much more quickly, but without any loss of integrity, if we increase those ceilings. Thank you.
Mr. Armstrong.
Thank you, Judge. I'm Gordon Armstrong. I'm from Mobile. I've been doing panel work since 1990. I've been the panel rep since 2000. After hearing all the lawyers today and then reading some of the submissions from prior conferences or prior hearings across the country that have been held, I really kind of grappled with what can I say that you hadn't heard? What am I going to say that might make a difference or what not? The last 2 days I was in D.C. Judge, I was up there for some meetings. I'm on the Practitioners Advisory Council group to the U.S. Sentencing Commission. So I've been gone for 2 days, and then I came here today. And course, I have 3 kids at home, and my wife is handling everything. And so when, I told her, well, I have to get up early and drive to Birmingham because I flew in last night from D.C. on work I don't get paid for. It's volunteer. And I'm going up here today, and she says, well, what is your benefit from it? What is your benefit? And then I started thinking, and I had this stuff prepared I was going to say, and I started thinking, what is my benefit? Why am I here? I mean, I've been invited to be here, and I know that what we're doing is important, but what is going to be the benefit to the CJA or to my panel, which is who I represent? What is, at the end of the day, what is going to be the end result? And if there's one thing I can ask this committee to try to work on, because there's lots of issues, but they're far ranging depending on where you are. Some circuits have different problems from us. In the Southern District of Alabama, it's much like Andy said in his district. I think our panel works well. The administration of the CJA works very well. I know y'all heard from Judge Bivens yesterday, and she's the magistrate in Mobile that handles, she's in charge of the panel committee. And we meet twice a year, and we talk about issues and vote on new members. And it works well, and it works well in Mobile because of how it was originally set up by Judge Butler back in probably in the late 80s or whatever. And he really had a selfish motive for creating our panel, which was he wanted competent, effective lawyers arguing cases in front of him. He didn't want people that didn't know what the guy, of course it was mandatory then, he didn't want incompetent lawyers. He didn't want lawyers that came over from state court that had never been in a federal case before and didn't know what it was to argue the guidelines and didn't know how the federal rules of evidence worked. And so our bench has been supportive of competent lawyers. And so we've never really, and that culture has followed through, and we've never really had a problem from our bench with either voucher cutting or if we need experts. And I don't know where we rank on that list in the Southern District. I see some eyebrows being raised over there, but we may be near the bottom. I don't know. I use experts when I need them. I know that, and I'm never denied. But if there's one thing that I can ask this committee to try to do is to work on compensation of the lawyers. Our hourly rate is embarrassing. It's embarrassingly low. And, who was it, Mr. Eddy in the last session talked about his panel. He'd put them up against anybody. Well, I'll put my panel up against anybody too. Some of the top lawyers in our community for retained federal work are also on the panel and do panel work. We have a small, Mobile is a big small town or a small big town, depending on how you look at it. We are at the intersection of I-65 and I-10, so it's a big drug corridor of drugs coming from Texas. No offense, Judge, but coming from Texas and then going to Atlanta or Miami or wherever they're going, they come through Mobile, and they like to indict in Mobile when they come through here because we have a conservative jury pool, and we're in a conservative circuit. And so they like to bring the indictments in Mobile. And so but there's been a transition of cases from the drug cases to now they're bringing more fraud cases. And the fraud cases are more labor intensive because they're more document intensive. We'll get a call, you got an appointment, can you show up in court, and we'll go over there, and they'll give me a small package with a disk in it, and they'll say, oh, and bring me 3 hard drives so that you can, we can copy the hard drives from the computers we seized. And I have to pay for that. I have to front that cost. And, I've got, and then, an hourly rate of now $129 an hour. And I have to pay for my office. I have to pay, I've got a mortgage. I've got 2 kids in college. I've got one in sophomore in high school who's 15, about to turn 16, and he wants a car, And every time I've ever gone to an oral argument at the 11th Circuit, when I'm done, I'm thanked. Thank you so much for being here. And they're sincere because they realize, and I think the judges in our circuit and the judges on our bench realize that what we do is very difficult to do, and then we get paid less than anybody, $129 an hour. I mean, that's really low. That's very low. That's lower than most of the experts that we hire to testify. Why are we getting less than the experts? Aren't we supposed to be the expert for our clients? And if there's anything I can, tell this committee is we've got to work on compensation. We've got to, and it can't just be lip service. It can't be, we've been talking about this, and the best resource for you is Chip Frensley, who unfortunately is not here, and I understand the reason for that. But Chip's been part of the district representative conference longer than I have. I think we both started about the same time. And we've been working on compensation from the beginning, from the very beginning. And it is, Tom mentioned $175 an hour. Boy, that would be nice, but it's still not what our peers get in the civil sector or in the private sector that do criminal defense work. But it would be a start, and that's a very good suggestion. And but that's what I would hope, that if anything can be taken away, that we can work on that. But not just say it, because everybody. I mean, we've had supporters on the bench that have in the judiciary that have gone to bat for us working on that. And I know it's Congress that controls that, not this committee and not the Chief Justice or anybody. It is Congress ultimately. And I wish I had the magic wand that said, okay, let's get these budgets increased, and because I know there's a problem with that. But if there's anything we can work on, that would be it. Thank you.
All right, Ms. Costa.
Hi, Lisa Costa from the Middle District of North Carolina. And
And I need you to speak into that one.
oh, I'm sorry. Is that better? Okay. I have been the panel rep for a very long time. Been on the CJA panel. I looked. I think it was in 1989 that I got accepted to the panel. So when I was first on the panel, I think the rates were, I want to say $45 an hour. So I dreamed of 129, but of course, many, many years later, being a solo practitioner now, knowing what it takes to make overhead, to pay employees, taxes, rent, all the things that you have to pay, 129 is not enough, and I echo what Mr. Armstrong said. Our panel has gone through some changes over the last few years. We have a new, or in the end of 2013, we had a new CJA plan instituted that then went into effect in 2014. Before that, our panel was over 90 people. And anybody that applied, it was a rolling application. Pretty much anyone that applied got on it. And the only decision was whether they were on a training or a regular panel. So when we decided to redo the CJA plan, we reduced the panel. We set out standards for becoming a member of the panel, a certain amount of practice, criminal experience, things of that nature. We then instituted a certain period of time to apply for the panel. Instead of some rolling application period that just went on all year, we open it up, then we close it, then we consider the applications, then we let people know whether or not they've been accepted, and then they begin that next January. And we have a CJA advisory panel now, myself as the CJA panel rep, another CJA panel attorney, someone from the public defender's office, a magistrate judge, and a district judge. And we meet, we discuss the applications, and then as issues come up throughout the year with panel attorneys, if they're brought to our attention, we might have a conference about that. Ultimately, it is the judges that make the decisions about the who's on the panel and maybe what happens when there's a problem with the panel, but I do believe that they listen to us. And so under this new plan, I believe we have always had really great qualified attorneys, but to me, it has taken our panel up to the next level. And the CJA panel is something that attorneys want to be on. It is, I get calls about it. Somebody goes into private practice. They want to know how to get on that panel. And so we have no problem attracting good attorneys. And I think we have some diversity. We have, I count, on our panel right now, we have 58 on the regular panel. We have a training panel. We have 8 people on the training panel. So we have some younger attorneys that are wanting to be on the panel, and there's some mentoring through the training panel matched with regular panel attorneys. So we are trying to bring up younger attorneys so that as our panel ages, we do have new attorneys ready to go. We have 12 women on our panel. We have 9 minorities, all African American on the panel. So, and we, as a part of our meetings, think about diversity and attracting diverse attorneys, qualified attorneys. So I'm real proud of that work. I submitted my testimony, and I'm sure y'all will have some questions about the expert issue that I brought forward. But I did want to give you guys an update just before we turn to questions. We just went to eVoucher. I just had my training in eVoucher about 4 days ago, and so it looks to me from the eVoucher training that our requests for experts are going to be done differently, and they're going to be done through eVoucher. There's still these 800, 2,400, all of that is still in existence, but the way the requests go through are different. I don't know what impact that's going to have on requests and approvals, but I'll be real interested in seeing that. And so that is going to be a change, and I'm waiting to see how that impacts. I have put in a couple of requests for some expert assistance since my training 4 days ago, but I have not received responses, so I can't really report on how that's going to affect the Middle District. And with that, I'm going to stop and answer questions.
Can I clarify something, Ms. Costner, because, and I may ask Dr. Rucker to clarify it even further, but just so the committee is aware, eVoucher has a portion of it where when you submit for a expert, it is a specific form, and then it goes through eVoucher. It's not a part of the record, because in the past you had to file an ex parte motion. Is that what you're talking about?
That's my understanding, and so there is for CJA 21, there's a request portion, so you put in the request and then you attach. It seems to me if it's going to be over 800, less than 2,400, I guess, or anything over 800, you're going to attach a motion. And that's going to go through eVoucher, and then you get noticed as to whether or not it's approved. Then you go back into eVoucher, back into the CJA 21 form, and you complete the rest of it. That's it. So far, I haven't gotten to step 2 yet, though. I've just done step 1.
All right, and the second part would be so that the expert can get paid. But my question to you is, so that's all done in eVoucher now in your district. Is that, are you required also to put something on file as part of the record, or is it only through eVoucher?
It's only through eVoucher from what I can tell. Now, and I guess the order is the CJA 21. I'm guessing, again, don't know, because I haven't received any response to what I put out a few days ago. If there may be some others that are further into eVoucher than I am, but okay. That's my understanding, that there's not going to be a docket entry.
Okay.
But I could be wrong.
And it is my understanding, just for the committee, that function and that ability, how that's going to be managed is completely dependent on how they set it up in each district. So some judges are going to be doing it the way you're talking about. Some judges are still going to require private motions, ex parte motions in their court, separate and apart from what's in eVoucher. And so that's a phenomenon that's happening now as eVoucher's rolling.
One thing I liked was the fact that there is a comment box. So when I submitted a request earlier this week, I could actually put in the comment box, here's why I need it. It was actually for more funding for an expert who had run at the end of their limit. So I'm hoping that will provide some further information to the court that we couldn't provide otherwise.
All right. So we'll start with Judge Fisher.
Thank you all for being here. And as you know, this is the 4th in a series of 7, and now we're starting to hear the same issues, which is telling us a lot. I mean, there is value in hearing the same issues consistently, because that's one of the things we have to decide is how consistent are these problems around the country, and which ones can we do something about, and which ones should we work the most on. So I'm going to ask you to take out the hourly rate, because we all know that's a hot button issue, and take out, although none of you has mentioned it, the re-elevation of the Defender Services Organization. and focus on the issue that we've heard a lot about, which is independence, basically independence from the judiciary, or with varying degrees of emphasis put on that. And I'll ask each of you to tell me from the perspective of your district, and you seem pretty happy for the most part, how could we improve it, if at all, with regard to that particular topic? Do you feel the need to remove all or part of what's presently done by the judiciary, take it out of the hands of the judiciary? Or are you happy with things the way they are? Mr. Stingley, could you start?
Based on my experience, I feel that the judges should stay involved to some degree. I do have some problems with the issue raised about you being a little over the maximum and it goes to the circuit and you have to wait 3 months. I think that's a problem that I think the authority ought to stay at the district level. I haven't experienced a lot of reductions, but I have experienced some, and the district judge I would get the message from the public defender's office that he or she reduced the amount because to alleviate the problem of going to the circuit. But that reduction would be done before I had a chance, in some cases, to respond to it.
So the judge reduced it so it wouldn't have to go to the circuit?
That's the way it was explained to me. And the reduction wasn't earth-shaking, so fine, I move on so I can get paid and that sort of thing. But I think the judges ought to be involved to some extent. Mississippi is still a relatively small state, and we generally know each other. We know the judges, we know the personnel, and part of practicing law is public relations to some extent. And so they know you're competent. In my case, I never put down all of my time that I spent. And I also realize that this taxpayers' money, and I'm also submitting a report to the federal government. I'm not submitting it to a private client. So I'm very concerned about what I submit and it's accurate and that sort of thing. But I think the judges should stay involved, particularly since they preside over the case. They know what happened in that particular case, and I think they should be involved. I understand the benefit of having a professional, an attorney, somebody with the experience, criminal defense experience, and being separated from it. But to me, in Mississippi, it's working okay, except for when those reductions occur that I mentioned earlier. But I think the judges should be involved to some extent. And I know the judges have a lot to do. I don't want to be overburdened with administrative duties, but I think it's just part of that job of the judge's job, dealing with those cases.
Thank you, Mr. Scar.
Thank you, Your Honor. Your observation is correct that this is sort of a happy panel. We obviously have good judges that take CJA representation seriously, but I have learned, I'm in the second 3-year term as CJA panel representative in the Middle District of Alabama, and when I go to the national conference once a year, I hear horror stories. I hear people tell me about judges that at best are indifferent and at worst are hostile towards CJA lawyers. So I think that our experience is not necessarily representative of what goes on around the country. That being said, I do think the judges are probably in the best position to advise panel leadership about performance of lawyers, about competence of lawyers, and about issues that judges are in a unique position to observe. We can't be everywhere at once, obviously, and the judges, we sought their input when we went through our first round of reapplications, and we got some very candid and very valuable input that we used in making those decisions. But I know that that's not the national standard, so I would caution the committee to be aware that there are folks in this country and in districts that have hostile benches, and that would be a concern to me. Thankfully, it's not a problem for us.
Judge, could I add just
Sure.
30 seconds?
Sure.
We have a real good federal public defender's office too, and the staff looks at all of those vouchers very closely, and I have a tendency to make
That
errors.
in your letter, yeah.
And they correct those errors, and they call me and tell me what they've corrected, and they make sure everything is sound before it's submitted to the court. So that's been a great help to the relationship we have with the Public Defender's Office.
Is there any concern about conflict that your panel has with the services the public defender performs with regard to vouchers or anything else?
Dennis Joyner makes a strong effort not to make sure that there's no conflict between the panel attorneys and his office.
Okay, thank you.
I mean, he brings that matter up quite frequently.
Mr. Percy?
Personally, I don't have a big problem with the judges reviewing, if we're talking about reviewing vouchers. I know the judges would love nothing more than to not have to do that. I know that the judges, no doubt, were thrilled when we removed the $3,500 compensation limit so they could quit reading all these memos about why every single case was extended and unusually complex. But the fact is that there has to be some kind of review system, and I know that and that means that there are going to be people reviewing vouchers, whether it's a judge or an independent office, and that means that there are bound to be cuts, no matter who's reviewing them. And I don't, as an attorney, I don't know who I would be more comfortable cutting my voucher: a judge who knew me, knew the case, or somebody in an office somewhere that didn't necessarily know anything about the case. And I'm sure there's in other parts of the country, we've all heard complaints about horror stories about vouchers being cut, and I'm sure there's resentment there. But I think the resentment is more just the voucher being cut, not so much as to who's cutting them. I'm sure the same resentment would be there if they were being cut by somebody else.
Mr. Mazzola?
When I was in high school, I had a teacher who asked the class, what's the best political system you can come up in? And people were saying democracy and so on and so forth. And he said, no, enlightened despotism. And enlightened despotism is the best sort of system you can have as long as you've got a good enlightened despot. And my experience in the Western District of Kentucky has been that the judges do a good job. They care about what they're doing. And so they are certainly, that system works. Whether a different system would work any better, I certainly can't say for sure that there is some model out there that's bound to be better. So at least I wouldn't say that the judicial centrality is necessarily a problem. It has not been for us.
Thank you. Mr. Armstrong?
I sure hope we're not going to ruin it for everybody else by being called the happy panel. And that all is going to be viewed as well. And I can speak for my district. I've never had a voucher cut in the years I've submitted vouchers, and we've been doing e-voucher since 2013. We have our clerk has taken the leadership role, Chuck Diard, and has implemented e-voucher. The lawyers are accustomed to it, are familiar with it. As Tom said, I think most lawyers in my district probably undercharge for their services or underdocument their services, and they don't add it in. If you're in a car and you make a phone call and you're talking about a case or whatever, and you don't have the mechanism to document it, you probably just don't do it. So most lawyers probably undercharge for the actual services they've done. I do not hear about voucher cuts as far as, having to go to the bench to get an expert. It makes you double think, do I need the expert? Because I'm going to have to justify it. And so it makes you it forces you to think about the merits of whether you actually need, and then how are you going to use that expert? I think there's certainly the other side of that coin, which also says, if I have to justify it and I need it, and I'm doing that ex parte, don't want to ruin this trick, but I'm actually laying my defense in front of the court and justifying my defense. And if it's not working toward the guilt phase, I'm certainly working toward mitigation, and how that might benefit my client in the long run. So I really don't have a problem because, like I said, it works in our district. I don't have a problem with the judge kind of being the gatekeeper on the vouchers or on the use of my experts. I do see in some cases that are the big look, 'cause we don't get the big, huge cases that sometimes they try for months. At least I've not been involved in one. So I don't. I know budgets are not as big of a issue. And in fact, since I've been doing it, I've only had to use the budgeting process one time in one case, and that was a large multi-defendant case where half the lawyers were retained, the other half were CJA, and we participated in having to be on a budget. But other than that, it's really not a problem. So despite not wanting to be the happy panel, I guess we're happy.
Ms. Costner?
I would echo the happiness in many ways. In my district, we don't have a problem with voucher cutting, and there sometimes is a problem with voucher delay. But I think I said in my comments, e-voucher may well take care of some of those issues. But as a panel rep and going to these national conferences and hearing the testimony in these hearings, I'm well aware that nationwide it is not necessarily the case. So then the question becomes, how do you do it in a way that where there are abuses and there are problems. You can't see your client more than twice or meet with the family and just all the things we've heard about. So it seems like there needs to be a solution where those folks can get what they need, get paid for the work that they're doing. And if that means taking all of it out of the hands of the judges and putting it into the hands of somebody in the federal defender's office that reviews vouchers and pays, then that may be what has to be done. In my district, it's not a problem, but I don't know that necessarily means that there doesn't need to be a change for the folks that really do have a problem.
Thank you. Okay, thank you.
Mr. Rowe?
Thank you. You're all panel representatives for your districts, so I wanted to ask you, in some districts, the federal defender or someone else, even the clerk's office maybe, send out letters to the attorneys when their vouchers are cut. And the letter basically says, sorry to tell you that your voucher's been cut by this much money. If you have any questions or you want to discuss this, please contact your panel rep, and then it gives the panel rep's name, number. Do any of you have a similar procedure in your districts?
Our letter doesn't say contact the panel rep. It says if 14 days passes and we don't hear back from you, we're assuming that you consent to this cut. But that comes from the clerk. It's not from the judge.
Okay, but does anyone have a letter that goes like that, and you are actually the ones who are notified?
Just a little different twist on that. Judge Bivens will call me. And this has happened one time where a lawyer, and it was a rather new lawyer to the panel, had been submitting vouchers and were getting some eyebrows raised about the time he was claiming. And she called me and asked me to get in touch with the lawyer and discuss his vouchers with him and how they were being viewed, and to try to assist him and maybe being a little bit more reasonable. And that's kind of the closest that we've come to a formal process.
Okay, so basically there's no formal process in any of your districts that you would get notified if there was a voucher cut? Okay, so when all of you have said that voucher cuts are not really an issue in your district, that is based on the fact that you're not hearing about them, not that you're not not that you're in the loop and you just don't see any. Fair to say?
Well, I send out emails to all the panel members, and I've asked them, or is anybody having problems with voucher cuts? And I've done that routinely, just based on the fact that when we go to the national conference, the CJA Panel Attorneys District Conference, which is in 2 weeks, by the way, in San Francisco.
We'll be there.
You'll be there, good.
All right.
We're very
And,
much aware.
I try to take an informal poll of everybody on the panel to talk about issues that I can then discuss when we get there. And that's one of the things I always ask, is anybody having a problem with voucher cuts? Does anybody have, and so I do try to find out, other than some kind of direct, contact from them or from the bench.
But the bench doesn't tell you. You're not notified from the bench.
No.
Are any of you notified that members of your panel are receiving cuts from the bench? Mr. Percy, I wanted to ask you a question. You also indicated that things are good in the Northern District of Mississippi. And some of the things that you said in your statement talked about the very high quality of the lawyers in your district, and they're very committed and dedicated folks. And I'm wondering if they thought things were really good in 2013 or 2012 or 2011, 2010, 2009. Would they have also said that things were really good at that point?
Well, we had our $3,500
I'm aware.
compensation limit at that time, and so sequestration and rate cuts didn't really affect us because we were hitting that maximum regardless of the hourly rate.
I guess my question is more that the fact that you had that $3,500 cap, so your bench had decided that no matter how complex a felony case is, that the amount that they thought was reasonable was for you to put 28 hours into that case. That's why I'm wondering, would you have said then, it sounds like, everyone comes in and says they're happy, but then you hear things like, that's, to me, staggering.
Sure.
That the bench would say, the rule is, across the board, that you can put 28 hours into a felony case. If you just plead it out, well, I could imagine putting 1,000 hours into a case that I just pled out. So I don't know how that is, how that is reasonable, but that's obviously the decision of your court. My question is did the lawyers really think that everything was good in northern Mississippi when the reasonable amount, the statutory maximum or the court-ordered maximum, was $3,500, or you had to file a memorandum, or as you put it, eat it?
Sure, that was a burden, and there were gripes about it, but we didn't know that we were the only district in the country.
So you were happy?
Thought that was the way it was.
Okay, so ignorance is bliss.
Correct.
All right.
Can I just ask a quick follow-up? Because we hear this, why do you guys do it? I mean, why do you take on this work and eat these expenses and pay it out of your pocket and put up with the $3,500? Why do you do it? Anybody want to answer?
Well, it's, I think everybody on these panels has a commitment to indigent criminal defense. It's a lot of courtroom work. You get in the courtroom a lot. You get a lot of face time with the judges. It's with the small size of our panel, it's lends a prestige to the panel work, but it's helping the clients, as I think everybody really has a dedication to that. On our panel, we have attorneys who are very successful in their private practices and would definitely make more money on an annual basis if they were not on the panel. But they enjoy the work, and it's you're helping. We see it as a service to the court.
You said that there were, I think you said there were only 14 members of your panel?
Correct.
and that as a result, you get a significant number of cases. Could you estimate how many cases a year your panel receive?
Sure. It dropped, last year it dropped off a fair amount, but I would say on average, each panel member gets 5 to 10 cases a year.
So folks on your panel obviously have a private practice other than just their panel practice.
Correct.
When you say last year it dropped off, is that, do you know why that, were the filings down? Was it because the Federal Defender's Office had to take more cases? Do you
That
know?
probably was part of it. Another part of it was the U.S. Attorney's Office in our district was indicting a lot of cases related to a white supremacist gang, and with multiple indictments, multiple defendants, and the panel attorneys were conflicted out early in that case, and those appointments. So that's the one instance, really, that I can think of where the small size of the panel had an effect, where they had to go outside the panel, outside the district even. But I think I attribute some of that to that. The panel attorneys were conflicted out of a lot of those cases.
Okay, thank you. Mr. Mazzoli, I wanted to ask you a question about the self-cutting that you were talking about. Again, strange term. People reducing their own vouchers, maybe is a better way to put it. When these vouchers, these excess compensation vouchers, go to the circuit, do you have success? Does the circuit cut more than the district court? What would you say about that? I know some of it is a time issue, that if it's just, slightly above the statutory max, it may not be worth waiting on it. But do you also have issues with cuts at the circuit?
No, I have not, and I haven't heard of any from people on the panel. That's not maybe necessarily the best reading, but as far as I know, my situation is fairly common for everybody, that if you go to the trouble of putting down a good memorandum explaining why your particular case is going over the ceiling, typically your judge, or whoever is the district judge who is signing off, will write a memo of some sort that supports your request, and that goes up to the Sixth Circuit. And I have never had a situation where it was cut after that. So I think, personally speaking, I don't do these self-reductions anymore. I found it convincing at one of our CJA panel representative meetings that when someone said, look, if you've done the work, claim it and get paid for it. And if you are reducing yourself, then if nothing else, you're giving the court a somewhat inaccurate view of what it takes to get these cases done. And who can blame judges if they never see an excess voucher, thinking, well, it must not be that expensive to do these cases. So again, still, if it were only $100, I might just let that go. But I certainly don't reduce like I used to. I'll ask for the excess and then wait.
And again, just so I'm clear on this, it's a matter of how long it takes to process the voucher when it goes up,
Yes.
not that you're concerned that it'll be cut.
Right. And I have to say, there is some burden in doing that extra request.
Memorandum, right, yeah. Especially if you do a detailed one.
Yes.
Mr. Stingley, I wanted to ask you a question about the vouchers that you talked about, where the court would cut them so they wouldn't go up to the next level, to the circuit court level. Do you know what the rationale was for that? Why would the court care about the voucher going up?
Well, the court didn't call me directly. I guess you might say the CJA person in the public defender's office called me to let me know, and that was somewhat the explanation. And I accepted it because I'd rather get paid than I give up a couple $100 or whatever to go ahead and get the money within 3 weeks versus 2 or 3 months.
Okay, so it wasn't a significant enough amount that you would wait, that it would matter to you? Is that what you're saying, basically?
Well, you know, sometimes things are relative. If I settled a pretty decent public personal injury case a month earlier, the way I look at that $500 or $1,000 is going to be different than if I hadn't settled one in 6 months. So everything is relevant when it comes to looking at money, but I'd rather not cause a problem for the court system in the work that I do on the panel. So I just, you know, it was fine.
Understood. Mr. Schreier, I wanted to ask you a question about the mentor program in your district. I believe in your statement you indicated that you've reduced your panel to, I think, 30 individuals. Is that correct? And you have 11 on the mentor program, on the mentor panel.
Yes.
And do those folks receive training? How are they mentored?
It's a two-tiered system. The people on the mentoring program are encouraged to contact a CJA lawyer and sort of follow that person around, follow a few cases. The lawyer and the mentoree are supposed to communicate about when hearings take place, proffer sessions, change of plea hearings, anything that happens in the case, so that they can sort of follow a case along and get some real-world experience in dealing with the issues that we deal with on a day-to-day basis, and also to make some personal connections with people in the U.S. Attorney's Office, people in the court system, and things like that. In addition, the people on the mentoring program are also subject to the same CLE requirements that we put on our CJA panel members, which is, I believe, 6 hours of CLE of federal related to federal practice, with 2 hours required for sentencing. I might be wrong about that, but I think that's what we came up with as a CLE requirement. And just for your information, all that is easily obtained through the Federal Defender's Office. They provide more than enough CLE per year at no cost to easily fulfill that requirement. But that's basically how the mentoring program has worked.
Thank you. I have some questions for Ms. Cosner, but I'll come back. I'll let some of my colleagues come to you, unless they don't, and then I'll be back. Mr. Armstrong, you wanted to say something?
Yeah, I just wanted to add something. When you were asking the question about, you know, how would your panel, what would they say about 5 years ago as opposed to now? And I know you were talking about the Northern District of Mississippi, but things have improved dramatically over the years as far as training and access to funds, and they are better from where. So a lot of time the people on my panel know how bad it was, because there was a time where you didn't have any training. There was no training at all. If there were any seminars, you had to find it on your own, and you had to go out and try to do it. That was try to educate you on the guidelines. But now in our district, there is required federal CLE that you have to get to stay on the panel. And in addition to that, our federal defender sponsors a free seminar every year that brings in wonderful speakers from across the country about a broad range of topics. And so, you know, a lot of our lawyers appreciate where we were and then where we are now. And so I don't want to say happy in general, but better than we were. And that's why I wanted to focus on, now let's work on compensation, because that is, I mean, to me, that is, and both aspects of compensation, both the hourly rate and the limits that are in place.
Thank you.
Mr. Kerr?
Can I add something? I don't want my comments to be misinterpreted regarding the Public Defender's Office, because they do a very good job. And listening to Mr. Armstrong, I was reminded that And the Public Defender's Office gives a free CLE once a year, and at each of those CLEs, the public defender will give us an update on what's happening with vouchers, how they're being viewed by the court, what to look out for when you are preparing the vouchers. We get an update on that every year. So communication flows. It's just that I receive 1 or 2 reductions. Most of the time, I don't receive them, but I did receive 1 or 2, and it was one I spent a lot of time on. So that's the reason why it sort of stuck in my mind a little bit.
Thank you. Professor.
Thank you for all of your testimony. I wanted to begin with a clarifying question for Mr. Armstrong. I wanted to make sure I understood a comment that you had made about being comfortable with the idea of the judges as gatekeepers, and in particular the question of whether you could ask for experts or investigators and potentially disclose your strategy, and understandably that's not something you'd want to do. I just want to make sure I understand, how then do you approach that conflict if asking for a particular expert might disclose that strategy? Is that a reason why you might not ask for the expert?
If I needed an expert, but I didn't want to tell the judge why I needed the expert, then I would. We have a relationship with our bench that I would call the judge and tell the judge, Judge, I can't tell you why. And I don't think I would be denied. I've never been denied when I've asked for, but most of the times that I've asked for one, and I'm thinking back now to specific instances where there was one time where the judge called me into chambers and, why do you need this? And this was on the record. Of course, my motion that I filed was ex parte because it was quite expensive, and I was trying to get an expert in drug addiction to testify that my client, who was accused of being a prohibited person in possession of a firearm, to evaluate my client and determine that he was not addicted to the medicine that the government was alleging he was addicted to. And so he was not prohibited. And the cost was going to be pretty steep. It was well above the limit. And so I filed the motion, and then the judge called me personally, and we had a phone conference about it, and then we had an in-chambers conference about it. And I was able to convince the judge that I needed it. And of course, then I got my evaluation, and he came back, oh, well, we think he's addicted. So it didn't really help me any. But I was not denied that opportunity. And so if it was a little different and I didn't want the judge to know, I've never really kind of had that fact scenario come up yet. I would just try to apply for funds within what the guidelines are for me to get, and just try to make it work under that amount.
Okay, helpful. So my broader question, this is for everyone on the panel, is how you deal with electronic discovery, which we've heard a lot of testimony about how a number of cases that have a lot of electronic discovery has dramatically increased over recent years, which really puts a strain on a CJA attorney who may not have the resources and certainly doesn't have the time to go through all of the documents. And I think it'd be very helpful for us just to get an idea of how do you respond to that? How has that changed your practices, your interactions with the U.S. Attorney's Office, how you go about your role as a defense attorney when you're just deluged with so many documents and so much material? So if maybe we could start with you, that'd be great.
I haven't not had any of the 2 terabyte cases. In the Middle District of North Carolina, we just don't have cases that are quite that document heavy. But in the Western District of North Carolina, where I also practice, I have one where it's a multi-defendant RICO case, gang case, where we got approval for a technology person to just put it all. I mean, these were interviews from different law enforcement agencies, all on different Everybody's got their own player and medium, for these interviews. So they made it all on one platform. They made everything searchable. They've made everything indexed. So they've made it very easy for all of us to be able to look and search and utilize that great amount of discovery. When I haven't had an expert like that, and again, not like a 2 terabyte case or anything, but just maybe 16,000 pages, I just sit down, I make it searchable, and I go through it. I mean, to the best of my ability. It is time consuming, and it can be difficult. But that's what I do. It's just I'm enough proficient that I can make it searchable. I can try to get it to where I can review the discovery, index it. I try not to print much. My iPad is sort of my trusty friend for those things. But it has been nice to have somebody that has taken all of the documents and put them in a format we can all use in the case I have in the Western District.
Well, without being flippant, American Express helps me because I have to finance it. I have to, like, if they give me a disk that has all kind of documents on it, I'll try to go through the disk to identify what I need, and then I'll take what I've identified as what I need. I take it down to ProLegal copies, and I say, print this out, and then they'll send me a bill later. And so I try to, float that bill as long as they'll let me, and then I'll put it on American Express, and then I'll, have to pay it when I pay it, when I can get funded for it. It's certainly a burden, which just goes right back to what Judge Cardone said. Why do you do it? Why in the world would you do this work? And I don't want to act like we're a bunch of ideologues, or we'd fight for the Constitution even if we didn't get paid. Because no, like Tom said, it's a business. You got to get paid. You got to have money to do it, and that's why I want our rates increased. We've got to, because it's hard. It's hard, and there are lawyers who will not get on the panel because they don't want to take appointed work because it doesn't pay enough. I put in my position statement that most of the lawyers are solo practitioners or very small firms that handle criminal defense cases. You don't get lawyers straight out of law school who are applying to get on the panel. They're applying in the big firms because they want to generate an income for themselves. It's very hard to stay on the panel. It's very hard to do any kind of appointed work. I don't know how people do capital murder cases in state court, like I guess Christine was talking about. I mean, to me, that's crazy. I used to do them, but it was when I was brand new, and I didn't have anything else to do. I was trying to learn. Who's going to hire a lawyer who's never tried a case before? Nobody. So you get an appointed case. So it's difficult to do, and it does put a burden on the back of the lawyer, and he carries it or she carries it, and you do the best you can under the circumstances.
I have not yet had a CJA case with a mass discovery, and probably have not yet in private practice until very recently had had a case that involves a mass amount of discovery. The strategy that I would try to use as a CJA lawyer, there's an awful lot of good support that you can get from the Defender Services in Washington. They've got their own electronic discovery specialist who can give you advice about software, and they have some discounts for software. So it could be that if you understand what your problem is and can describe it to them, they can give you an answer. Sometimes the government will cooperate, and they really ought to cooperate all the time. They should give you discovery in searchable format and a few basic, decent things that they can do with the evidence to at least make it a little easier to use. If I didn't get cooperation from the government, I'd complain to the judge, and I would say every hour, they're refusing to spend a few hours, and they're going to force me to spend 100 hours. Maybe you can get them to make that. The one other thing, and then I've just learned this as a kind of a strategy, is to approach it in a staggered sense, to get an expert just to look at what the problem is, and come up with a plan that would sort of itemize, this is what you would do, and this is what it would cost. And then maybe with that, because that's probably going to blow the top off of the ceiling for experts, but maybe with that you can go to the government and say, I'm sorry, to go to the court and say, the government won't cooperate, this is what the expert said. Now the expert, if they've only done a consultation, that should be reimbursable by CJA, I think, regardless, if it's below the proper amount. But you can use that little bit of money that you've got for an expert to at least get an estimate as to what you really need. And that would be what I would try. And I'd have a good feeling, if I could make a good case to the judge that we've tried with the government, they won't help. I've called Washington, they can't really do anything because whatever their reason is, then I think I'd have a decent shot. It's not easy. I mean, I have not even brought up the idea of a case with 100 hours of audio. I mean, I don't know that there's anything you can do but listen to 100 hours of audio, even if the government says, well, really, there are only about 2 or 3 important tapes here. I think you have to listen to all 100. I don't know that there's any software that'll do it for you.
I have heard some complaints from a panel member or two about getting discovery in a large, what they call a data dump. But I'm not suggesting that the U.S. Attorney's Office is deliberately giving a data dump to hide, the relevant evidence amid. Thank you.
I would say that. I've experienced that.
In my own experience, I have and I think most of our panel attorneys have good relationships with the AUSAs, and I don't hesitate to call them up, and they don't hesitate to speak to me and tell me exactly, what and where, the phone. Here's the calls. These are the numbered calls that you need to listen to. And of course, you rely on that solely at your own peril. But you have to look for, like you say, you just have to listen to 100 hours of audio. But it's a good starting place that you can go to your client with. I've got I'm struggling right now with a case with a large volume of discovery that was provided in an electronic format, and it's in an encrypted format. And I was given the code to open it and view it, but the encryption prevents me from making a copy. And defense attorneys differ. Some panel attorneys and federal defender attorneys don't like to give their clients a complete copy of all the discovery. I tend to, I do like to do that. And in this case, my client lives an hour and a half away, and I can't copy this discovery even onto an electronic. I'm not talking about making a hard copy for them. I just want to copy it onto another flash drive, but I'm having trouble doing that. I'm trying to resolve that without a motion to compel, but the court, in other cases recently, has entered protective orders at upon the motion of the U.S. Attorney's Office, preventing defense counsel from making copies of discovery because they've had some issues with the confidential informants. A couple have been killed, so they've got certainly some security concerns. But that's an issue I'm struggling with now, is how I can make it available to my client, and I'm not necessarily expecting my client to go through it all, but I want them to have had the opportunity to view all the discovery.
I want to thank you for that question, Professor, because I think it brings up an even more important point than our individual experiences. This is a world of limited resources, and I think, would all agree that we need to use the resources that we have the most effective way possible. I'm involved in a case right now. Someone just mentioned a multi-defendant case with hours and hours of wiretap audio. I have a case like that right now. And I remember thinking to myself, every time I fire up this player, I'm billing the government $12.90 to listen to it. And so are 9 other lawyers, because there are 10 co-defendants in this case. And I remember thinking, that's not a good use of our time. I don't know the answer to it, but I think one thing that might be helpful, I watched some of the other testimony from some other hearings, and I think at the Miami hearing, there was some discussion about some changes to the rules to require the government to indicate which documents they intended to use in their case in chief. I think that would be very helpful. Putting requirements on electronic discovery, that it be searchable, that we be able to make copies and be able to share with our clients. I think that would be very helpful. There's no reason for this duplication of effort, and frankly, it's a waste of the limited resources that we have, and we're not doing the most effective job that we can for our clients when we have to do the same job 10 times because there's 10 co-defendants in the case. And it's a problem that's going to get worse. It's a problem that's gotten worse since I've been practicing in federal court, and it's a problem that's not going to get any better because, at least in our district, wiretaps are the new vogue, and that's what's coming down the pike. I'm glad that the committee recognizes that is an issue. Other than what I just said, I don't know what the answer is, but I do hope that it's addressed when y'all make your report.
That's a very important question. I've received anywhere from 2,100 to 3,000 hours of wiretaps that the government submitted me. So my approach is I listen to some of it to see who the target is, particularly if it's a multi-defendant case, who the target is, how does my client fit into that scheme of things. And if I hear enough concerning my particular client, I'm going to meet with my client and go over the discovery with that client. I'm not just going to give it to them or say, we're going to sit down and go over it. And if my client is opposed to it that way, I go back to the government and I'll send an email or a letter indicating the problems I'm having with the discovery, and I can't find any culpability in this discovery. And most of the time, if you've established a relationship with the government attorney, and they respect you in terms of being serious about what you're doing and that you're not going to push anything that doesn't make sense. They know how you practice. They will come back and point out what's important. I'm not saying that they're going to give you their case strategy, but they will point out to you. Then I'll do that, but you have to do due diligence, and I might have only listened to 500 hours of tape. I got that other 22,000 hours out there that I need to listen to, and the best use of time would be to hire a investigator, a skilled investigator, or a skilled paralegal to listen to it once you've given them instructions on what to look for, and let them be billing at a lower hourly rate than the attorney. That's what I would rather do, but sometimes I'm forced to listen to all of it myself.
Microphone.
You indicated that there were some recent changes in the discovery process in your district. You indicated when you received certain information, but you didn't say now when you're receiving Brady.
Well, the new scheduling order, and that's actually what precipitated the new scheduling order is an instance where some Brady material was not disclosed in a timely manner. And the new scheduling order, and there was discussion about when the Brady would have to be disclosed. This scheduling order says promptly after the United States learns of or obtains exculpatory information, which we take to mean immediately. But their concern, and the U.S. Attorney's Office was at the table along with the Federal Defender's Office and the panel in crafting this order, but their concern obviously was they don't always learn of Brady material until after, maybe even mid-trial sometimes. So we settled on promptly. We were so thrilled to get the witness statements now 7 days prior to trial, and impeachment material regarding witnesses 7 days prior to trial. That's just a huge leap forward for us, and I have no doubt will ultimately result in a big cost savings for the CJA program, because it will obviate the need for some trials if you can confront your client with witness statements before the witness has actually testified. So, but there is no drop-dead deadline for Brady materials.
Dr. Rucker, do you have any questions?
Maybe a couple of quick questions, or I hope are quick questions anyway. I want to continue on with the idea of the discovery and the difficulties you're having with the e-discovery. Have any of you ever used a discovery coordinating attorney to help you with this, or used Sean Broderick's office, the National Litigation, to help you with any of these issues?
Not yet.
If not,
In the Western District case I have, I think it's Russell Aoki, I think, who's out in West. He's helping, and he put it all together for that case.
Okay. And as a follow-up to that, have you had training on managing these large e-discovery cases?
In our case, yes, they actually had training sessions for everyone and individualized training sessions, and so it was very helpful.
Any of the rest of you?
yeah,
Training.
no, well, the training that we've had is, well, for me personally, is through the CJA Panel Attorney Conference. You know, Sean and his team usually attend all our national conferences, and so it's constantly at the forefront of the conversation is what they offer and what they do. And then locally, on a local level, the seminars we have usually touch on that type of case management system and how you can try to get a handle on the electronic discovery, especially in the very large cases.
Just go to. I have one more question, if I may.
Sure.
Okay. The other question I wanted to ask you about is a number of you have talked about sort of self-cutting your vouchers. I think Mr. Mazzoli said you're no longer doing that. Did any of you keep track of how much time or how much money you were not billing for voluntarily?
I have never cut my own voucher. In fact, I've had other lawyers tell me that they did that to get under the cap, and I said, don't do that. I said, you know, you're devaluing your own service, your own time and efforts. And I have always tried to keep very good track of any time I've ever had. But there are times I know that I've probably underbilled, but I didn't do it because I chose to. I did it because I probably couldn't document properly that time, and I didn't want to guess and get into a situation where I'm guessing as to what my time was, even though I knew I'd expended more time. But I encourage the lawyers on our panel that if you put the time in, bill for it. Do not cut your own voucher, because I have had lawyers in cases that I've been involved in with excess, that would end up in excess vouchers, saying, well, maybe we ought to get together and compare our notes and make sure we're about the same level so that it all looks like we've, you know. And I said, look, just put your time down for what you've done and bill for it. And then, you know, if you're called to question to justify it, then justify it. Because I'm not going to, I don't like somebody else telling me my time's not what I put into it. I don't think that's right that anybody should do that. And I would, you know, I would defend my voucher, but I've never had one cut, so I've been fortunate in that sense.
I had one voucher cut when the only voucher I've ever had cut, and it was back when we had the $3,500 maximum, and the judge called me personally, which is, I think, is the ordinary practice when the rare occasions when vouchers are cut, and the reason was not that I had billed too much for the work that had been done on the case. It was that the other attorneys on the panel were, you know, they were submitting $3,500 vouchers, and it was just not fair for me to submit excess vouchers if they were cutting their vouchers. So after that, I was, so I did cut my vouchers. I kept my vouchers. I was pretty strict. There's nothing worse, no worse feeling than getting a voucher cut. And so I did cut my vouchers. I did not keep up with how much I cut. It was thousands upon thousands of dollars. The one benefit was that when you renew your bar membership every year in Mississippi, you're to report that you've done at least 20 hours of pro bono work or paid $200 to the bar. And so you could always put, that you had done, 100+ hours of pro bono work.
All right, anybody else? I thought you were a doctor. All right, I want to thank all of you for being here. We very, very, very much appreciate you guys for the last panel, and so you've been here, I assume, some of you for a while. I know Mr. Mazzoli's been here for a couple of days. But again, thank you very much for being here. Thank you very much for your appearance, and we stand adjourned. The committee has a meeting, short meeting.